The Honorable Chief Justice and Justices of the Supreme Court of Ohio. Hear ye, hear ye, hear ye. The Honorable Supreme Court of Ohio is now open session pursuant to adjournment.
Good morning. You may be seated. First case on our calendar is 06-957 Prouse Dash and Crouch versus Prouse, Gorcyca, and DiMarco. Mr. Lindner.
Good morning. May it please the court, my name is Dan Linder. I'm the attorney for the appellant, Prouse Dash and Crouch, and I'd like 2 minutes for rebuttal, if I may.
Watch your time there.
This morning we have an unusual fact pattern. I represent a law firm out of Toronto, Canada area, who represented an Ohio resident who fled criminal prosecution. And when he was first retained on this case, he was really retained to argue to Canadian officials that Mr. DiMarco should not be deported back to the United States because he had resided there less than 6 months. And now, once we brought our case in his residence county, which is Cuyahoga County, he owns a house in Parma, he argues, no, I'm a Canadian resident, and you don't have jurisdiction over me. The Canadian court did in fact find that let me back up. Mr. William Gilmore, the attorney from Prouse Dash and Crouch, was first hired to come down to Cleveland, Ohio to take witness statements to prove to the Canadian courts that Mr. DiMarco was in fact not in Canada for 6 continuous months. And he argued it successfully, and over time represented him and his wife on a number of other matters. And I obtained a judgment for legal fees in the amount of $250,000 Canadian, which translated to 206 in US dollars, by bench trial with Judge Janet Burnside. The Court of Appeals, though, ruled that the court had no personal jurisdiction over Mr. DiMarco. And in fact, the trial court said they were exercising their in rem jurisdiction. And so we find ourselves here today with a number of interesting issues that have popped up as a result of this unusual fact pattern. One is, what is a resident? Or in the context of the long-arm statute, what is a non-resident? And there's a number of statutory definitions found in other areas of the law, but not really in the area of jurisdictional inquiry.
Is there any question that he moved to Canada to flee the United States because he was being sought here?
That's not in dispute. In fact, at the time he moved there, he had an Ohio driver's license. He owned a house free and clear in Parma. He had an Ohio bank account that he actually kept in his mother's name, but he was a co-signer on.
This case really could be decided on the residency issue, could it not?
Arguably it could. The question, though, is was he a resident, or does he lose residency status when he fled? But yes, it could be decided on the residency.
If we did not have the complication of him fleeing to avoid jurisdiction in the other matter, would there be any question that Ohio did not have jurisdiction here?
I'm not sure that I understand.
He moves to Canada. Everything else is the same. He had a driver's license. He ends up moving to Canada, takes up residency in Canada. You try to sue him here in Ohio. If you did not have the factor that you're alleging he fled to Canada to escape the jurisdiction of Ohio courts, would you have a problem? I mean, would he be a Canadian resident? You'd have to go after him in Canada. I don't believe so, and here's why. The minimum contact standard, as well as a long-arm statute, he still owned a house free and clear here. But more importantly, the first thing... Yeah, but owning a house I mean, people own property all over, and that doesn't mean you can sue them where they own the property.
Yes, I would agree with that, but for this court, as well as other courts, have said that one purposeful act within a state does give personal jurisdiction. And in this case, the first thing that my client was hired to do was come here to interview witnesses to create his defense. And he still had bank accounts. And the interesting thing about the driver's license, that's another one of these statutes that uses the term resident. And in order to get an Ohio driver's license, you need to be either a resident or a temporary resident, but it's not really clear what that means either in that context.
But if you had to go to Kansas to interview witnesses, that wouldn't give Kansas jurisdiction. I mean, that standing alone isn't enough to give anyone jurisdiction just because you go to a state to interview a witness.
Well, the question, I believe, is purposeful contact with the state, and I believe that was raised by this court in the, I believe the case was called Schaefer.
But the contact with
I'm sorry, it's Fulling versus Hickey.
the contact with the state didn't have anything to do with the nature of the transaction between the law firm and Mr. DiMarco. That all arose in Canada, did it not?
Well, I don't agree with that, actually, and here's why.
Well, he surely didn't retain the Canadian law firm while he was a resident of Parma.
Actually, yes, he did. He was, in fact, arguing to the Canadian court that I am a resident of Parma. I've lived here many months. This is where I was. I've been in your country less than 6 months. I don't intend to establish residency here.
The claim for legal fees arose in Canada.
The firm was in Canada. They met in Canada. The work was performed largely in Ohio.
But
at the time they met.
It's a contract action.
I'm sorry?
It's a contract action between a lawyer and a client.
A contract or a quasi-contract, yes, that's right.
Which arose in Canada.
It arose originally in Canada, that's correct. But I don't believe Canada would have jurisdiction to hear the decision based on the fact that they are deporting this individual, and he specifically was telling them, I'm not consenting to be part of your jurisdiction. I intend to remain in Ohio. And that's what he had to tell them so that he wouldn't get deported.
How does the fraudulent conveyance work into this? Now, that involved property, and that involved property in Ohio.
Yes.
And that involved, I don't know, what kind of jurisdiction was that?
Well, that's interesting that you raise this. There was not only the fraudulent conveyance, but there was the criminals' acts and the criminal tools upon which this individual was committing his alleged crimes were also based out of this house in Parma. The transfer of the land subsequent to the action here indicates an intent, while there was a pledge, an oral pledge, to my client that they would in fact sell the house and pay him from proceeds. And then they transferred it to the wife so as to defraud creditors. That act also occurred during this time period, and that also would be a purposeful act within the state of Ohio, I believe, as it relates to the minimum contact standard.
In order to successfully challenge a transfer as being fraudulent, does the creditor have to be a judgment creditor, do you know, or can anyone who has a claim commence an action?
I do know that answer, and under the fraudulent conveyance statute, it says that anybody who actually is a creditor or reasonably believes they're going to be a creditor has the right to bring this action. And a fraudulent conveyance occurs when there's a transfer to an insider that was done to defeat actual creditors or potential creditors. It's when, in fact, there is knowledge that a suit could be brought.
Thank you.
In this case, I believe that, first of all, we don't even get into the minimum contacts and long-arm statute inquiry because this individual, the evidence is clear in the record, actually. The wife came down to testify, as did his other witnesses. Everybody came here but for Mr. DiMarco. And the wife testified, we lived there many, many months. We owned the house. And that was the last place they lived before he went on the lam. There is no other place that could possibly have jurisdiction on him. He's purposely not availing himself to any jurisdiction.
You did argue estoppel, but if he argued in the Canadian court that he was not a resident of Canada but a resident of Parma, is there any estoppel here?
The answer is...
He could be inconsistent, I guess, right, depending upon the circumstances.
There's certainly an inconsistency, at best in irony, that he's tweaking this factual scenario to whatever's convenient for him as far as the relative defense he's facing at the moment. I guess I don't know what sort of precedential value making that sort of argument up there would have down here. So I'm actually unprepared to answer that question. But it's certainly an inconsistency.
Counsel, is the transfer of the home to the spouse recorded?
Yes.
In Cuyahoga County Recorder's Office?
Yes.
Which is obviously located in Ohio?
Yes.
Okay, thank you.
And, the one thing that's interesting also in this case is that There hasn't been that much argument in opposition to the jurisdictional issue. It's been more on forum nonconvenience grounds, and I thought I really should address that briefly. First of all, where this individual lives is closer to Cleveland, Ohio than Cincinnati is. And all the witnesses did in fact attend, but for him, and it's because he chose not to attend rather than couldn't attend. He's welcome in our state. I imagine he's welcome in a number of facilities in our state, but he did not come back.
Counsel, over the other side here.
I'm sorry.
Thanks. Was there, and I've been kind of curious about this, was there a legal impediment to bringing an action for the attorney fees in Ontario?
I believe there was. The fact that he was not, he's an American citizen, the fact that he was specifically saying, I'm not availing myself to your jurisdiction because I haven't been here for 6 months. I believe my client really couldn't, or at least it's questionable whether he could bring the action in Canada. As we stand here, he's still in the process of deportation proceedings.
So they have a 6 months residency or 6 months duration in order to become a resident, in order to be amenable to service of process?
You violate the laws regarding visas if you remain in a country without a visa for 6 months.
I mean, I understand the visa immigration issue, but does that then apply over just to a common debt issue as well?
I don't know that answer. But what I do know is that he specifically was arguing and continues to argue, I was an Ohio resident, but then he came here and said, I'm not. He's not a resident of anywhere if we allow him to simply lose his residency status by just popping around to avoid prosecution.
Didn't he return to Ohio periodically so that he would not be could not be determined to be a resident of Canada?
That's the evidence that was put on in Canada. That's what the witness statements did in fact say. Furthermore, my client was hired to come down here to secure the real estate and the property inside of it. There was a flood in the house. My client was hired to come down here because, again, there was fear that if Mr. DiMarco did, he wouldn't be able to return to Canada. Well, moving along, there's plenty of contact with the state. My client was also asked to get the computers. There's a public policy issue here with regards to this forum nonconvenience, and that is, are we going to allow someone to say it's inconvenient for me to come to this forum just because he's going to be prosecuted? I don't believe that that's the message that anybody's looking to send. I think there's also an inconsistency with regards to whether or not you have to satisfy both minimum contacts and the long-arm statute inquiry when you're presenting this issue. But again, I think Justice Moyer was correct when he said if we establish that he was in fact a resident, we don't have to go any farther down this path. I just thought it was something that would be more global for the Supreme Court to possibly address on these facts. Furthermore, I guess ultimately...
Counsel,
yes.
We fairly recently decided a case in a woman who left her Cuyahoga County home to move to California.
Yes, the Barth case.
Yes. Only to find out that California isn't where she wanted to be.
Right.
And we said, tough luck, you're not a resident of Ohio anymore because of the things that she had done in California. She may still have had an Ohio driver's license and some of the other indicia. How does that case square with the position you're taking?
I have two answers for you. One is that was a domestic relations case.
How would that be any different in terms of the issue of residency?
The residency is a creature of statute under divorce, and it says that 6 months intent to remain in a particular place.
It just says you have to be an Ohio resident for 6 months before you file.
Okay. Well, the second part of my answer is also the fact that Mr. DiMarco has indicated an intent not to remain in Canada, which he's testified to in front of the Canadian authorities. And so...
But his reputation for truth and honesty isn't very good, is it?
I won't argue with you there.
And you're representing a client who essentially took on a guy with a really bad track record.
There's a lot of criminal defense lawyers who have to do it pretty regularly, yeah. And quite honestly, you know, one of those issues that's hanging out there, and everyone, and I wondered it too, is why would they continue representing this guy when he's running up such a debt? Heads nodding everywhere. And I think the best answer, and I guess you'd have to know my client, but the best answer is, listen, he takes his role as an advisor and a counselor very seriously, and he felt he would cause more harm to the client if he were to withdraw. I mean, his files are enormous. They're boxes. And he continued on a verbal promise, figuring I'll deal with the ramifications of that down the road, and that's where we're at now. But he took his role as a guidance and a counselor very seriously. Didn't want to prejudice the client.
Counsel, the contract between the attorney and Mr. DiMarco was not in writing. Is that correct?
That's correct.
Does that have any impact on what you're seeking here?
The answer is I do not believe so, because the Canadian law, which would be the substantive law of the case, says that verbal contracts for lawyers are okay. Until recently, that was true here also. I guess it technically still is. There's a quantum merit claim at least on this case. So that's under quasi-contract. I notice that my time has passed, so I'd like to just ask that this court overturn the 8th District's ruling that there's no jurisdiction and actually modify the trial court's ruling stating that there's more than in rem jurisdiction in this case, but there's also personal jurisdiction.
Thank you, Mr. Linder. Mr. Mancino.
Mr. Chief Justice, and may it please the court, I think in this case you have to go back to the beginning here. This is merely a contract action between a lawyer and a client. Mr. Gilmore and his
What do you
law
mean
firm,
merely?
Well, Mr. Linder wants to bring in all sorts of things, whether he was fled, how he fled, what he was doing, or anything. We're talking about a hiring of a lawyer after he was detained in Canada to represent him to defend against extradition proceedings in the United States. All of the legal services were rendered in Canada.
Where do you say your client resides, Mr. Mancino?
He resides in Canada. He has a family there. He has a child there. He's married, and he's lived there.
Has he not indicated that he would not subject himself to that because he claims to be an Ohio resident?
That I'm not aware of because we didn't have his testimony. The court refused to allow a deposition to be taken of him in Canada in connection with this case, which really I think this lawsuit was brought to take advantage of the fact that they know he could not come to Cleveland to defend this lawsuit because there was a risk that he could be detained in the United States.
What's curious to me is that there's a claim here of a fraudulent transfer of the title of the property from him to his wife in an effort to avoid a claim by his first wife. You aware of that?
Yes, but that has nothing to do with that's the allegation there that it's allegedly he owed, I believe, some back child support. Now,
wouldn't there be some jurisdiction with respect to the fraudulent transfer because the property is located here, either
well, I would think
in rem or quasi in rem?
Well, yes, but the claim of the plaintiff, this transfer was made much prior to the time that any contact or any contract or requesting of legal services was rendered. But it's really a sham because the lawsuit was a joint several. The plaintiff claims that Mrs. DiMarco, Linda DiMarco, owes the money also. So, I mean, it's a transfer from Bruce to Linda, and it's a joint thing. So really there's no fraudulent transfer. You have a judgment against both of them. So I don't know how you factor in a fraudulent transfer under those circumstances.
What I'm trying to get to is your analysis of the court's ability to exercise jurisdiction as a result of the fraudulent transfer, and then the application of the rules on compulsory joinder, that we join all the claims in one lawsuit for judicial economy, among other things, and thereby vest the court with jurisdiction in this instance over all of the claims because it's pending here. And if it's properly pending as a result of the fraudulent conveyance, then why wouldn't all the other claims be here under joinder rules? I'd like you to address that if you could.
Well, I don't think joinder applies in this case because the statutory basis for jurisdiction on a real estate matter is confined to the real estate matter solely. And you can't add on to that to try to get a issue concerning a legal fee, because the underlying claim is for legal services and a claim for legal services.
But if one party is before the court alleging that there's been a fraudulent transfer to avoid payment of a claim that I have, a just claim, isn't that party obligated to bring all the claims they have against that individual in the same court at the same time?
No, I think they're obligated to.
You think they can have the case for attorney fees someplace else? Is that what your view is?
Well, if this were, within the state of Ohio, I would agree with that proposition. But here we have someone in Canada, no activity relating to the contract concerning attorney fees was done in Ohio. The contract was in Ohio, and the plaintiff claims the contract was not only with Bruce, but also his wife. The court rendered a personal judgment in this case against both of them for $206,000 plus in connection with this case.
Is it your view that he should have been sued in the Canadian court then?
Yes, he should have, because the court even acknowledged that to decide this case on attorney fees, we have to apply Canadian law. But what better place to apply Canadian law but a Canadian court?
In response to another member of our court's question, the indication is that he was not amenable to the Canadian jurisdiction because he claimed residency in Ohio.
Well, I don't know that there's any merit to that. I mean, you serve them with papers. I don't think the Canadian process is much different than Ohio. You file a lawsuit, the parties there, they get served in that case, and if that's a issue, you raise it in that court and not in Cuyahoga County, miles away from where is that, Mississauga, Canada.
Did your client, in fact, claim that he was not a Canadian resident, that he was an Ohio resident in the extradition proceedings?
That I'm not aware of, because I don't think the extradition proceedings had advanced to a merit proceeding at that time, at the time that the services, this was just all preliminary matters.
Are you not aware of what your client pled on an issue that's germane to this case?
Well, I did not represent him at the trial in this case, and I'm just going from the record that was developed in this case. He was obviously fighting extradition.
So if this attorney files suit in Canada, are you going to deny residency in Canada and claim you're an Ohio resident? Is that what your client's going to do to defeat jurisdiction on this case as well?
Well, that I'm not aware of how he's going to proceed. I don't know how you can say it where he's there and he gets summons and he's served in Canada. I don't think residence, I think that's just a red herring.
Do your admissions in this court bind him to an admission of residency in Canada?
Well, that's where he wants the lawsuit filed, so I presume he will defend it on its merits in Canada, because he's also brought, as I understand, he brought some collateral actions concerning the reasonableness, the amount of attorney fees before a Canadian tribunal in Canada in connection with this matter. So,
will we find evidence in the record that indicates that your client traveled to Parma periodically so that he could avoid being a resident, status of being a resident in Canada?
I don't believe that has any bearing on the issue here.
We'll decide that.
Oh.
Let me ask you again. Will we find evidence in the record that he did that? He traveled from Canada to Parma so that he would not establish residency in Canada.
Well,
do you know the record?
No, I don't believe that's in the record
we'll
there.
Find it if it's
I mean, he didn't testify, so I don't believe that's in the record there. But I think the contact in Ohio, the activity in Ohio, has to be related to the underlying contract that is being sued on.
Well, is there evidence in the record that he represented to the law firm that he had property in Parma, that what he didn't have a written security agreement, obviously, but that was somewhat security for his payment of the fees? Is that in the record?
That's in the record that he had owned this property in Ohio.
So the property and the fraudulent, so-called fraudulent conveyance is relevant, isn't it?
Well,
they're depending upon his representation to them that I own property in Parma, Ohio, and I can pay your fee because that property is going to be sold. doesn't that bring the property into the factual, important factual?
I don't believe so, because the transfer from Bruce to Linda was even before there was any, even before these two parties knew each other. So they had no, it was not done on it.
What about the personal property that was referenced as collateral? In fact, based on my reading of the briefs, the representatives of your client, who were his attorneys or members of the firm at that time, traveled to Parma to inventory personality and the home. Is that true?
That was they did testify to that, but it had nothing to do with defending him on an extradition proceeding.
Well, wasn't the representation is that I have an extensive doll collection that I could sell and pay your legal fees with this?
Well, there was testimony to that effect, but still, if they...
So that's property in the state of Ohio that he is pledging
Right.
For this legal debt.
Correct, but get your judgment in Canada, then bring it to Ohio and execute on it. Get a determination by a Canadian court how much money is owed, if any. And with that judgment, it would be honored in Ohio, and then bring your action, whatever type of action, if you want to foreclose, if you want to attach.
Hey, what jurisdiction did he owe the $100,000 in child support? I haven't been able to determine that.
I believe it was in an Ohio court. I think he was married, and I think he got divorced in Ohio.
So he's been subject to Ohio legal proceedings in the past via non-support.
Correct.
And termination of his first marriage.
Yes, he was divorced here, yes.
Okay, so he's divorced in Ohio. He takes advantage of Ohio courts for that. He owes child support to a child support enforcement agency here in Ohio. There's a judgment against him here in Ohio. Am I correct on all that?
I don't know if there's a judgment. I know there's
Well,
an
for
arrearage.
$100,000 of child support arrearages, you need a judgment.
Well, if it could be reduced to judgment, it may not have been. I'm not sure about that. But assuming that is accurate, that would be between the first Mrs. Gorcyca, DiMarco, and Bruce, not between the law firm and him. The law firm had nothing to do with
Well,
that.
we're concerned with his residence and status here in Ohio. That's our job to determine that today.
But I believe he could be a resident of both. You could have dual residencies. People have dual citizenship all over the
But
world.
the United States doesn't recognize dual citizenship.
Well, I don't know if they don't. I understand. I understood that they did, but that may be. I'm not an expert on immigration, but I believe.
Well, is he alleging dual citizenship?
No, he's just alleging that they had no jurisdiction to sue him in Ohio. That's his issue in this case. He asked that the.
But he consented when he was part of a domestic relations case.
Yeah, much prior to this. I mean, the domestic relations case and the divorce case, he could have left years ago, and if his wife still lived in Ohio, she could have sued him in Ohio. But it certainly had nothing to do with Mr. Gilmore and the appellant's claim for attorney fees to resist or defend an extradition proceeding. So they really had nothing to do with that. So it would be to get your judgment in Canada, bring it to Ohio, and then execute it on Ohio. That's what it could have been easily done in connection with this case. So I think the Court of Appeals reached the right result. There was no jurisdiction, and the case should be heard in Canada. Thank you.
Thank you, Mr. Mancino. Mr. Lindner, use your time, which may take 30 seconds.
Sure. 2 quick points, and that is, one, I don't believe somebody can be a resident of somewhere they're not legally entitled to be. In this case, he's not allowed to be in Canada, and he's about to be deported back here pending Canadian Supreme Court hearing. Second of all, this lawsuit, just to clarify, was brought in Ohio solely because we were concerned Canadian courts would not have jurisdiction. It was not done to subvert the process. Accordingly, I'm asking that you overturn the 8th District and modify the trial court to say that we have personal and in rem jurisdiction on this matter. Thank you.
Thank you, Mr. Lindner. The case is submitted. You will be advised of our opinion.